In keeping with the theme of definitions, declarant. I don't know about you, I always had trouble wrapping my head around who the declarant was in a trial. I like to boil it down to its bare bones. It's the person who makes the statement or the assertion. The main issue is this. Is the declarant the same person as the in-court witness, or is the declarant an out-of-court person? All right, so as you are observing the person testifying, you can identify, you should be running through your mind, is this in-court person the declarant? Was he or she the one who uttered the statement? Or is the declarant, or is this in-court witness repeating the statements of someone out of court, of some out-of-court person? So, to break it down to its bare bones, is the declarant the person testifying in court, or did someone else make the statement that the witness is offering? Hearsay. Definition is pretty straightforward, but as we all know, it takes up 3/4 of our evidence book and gives us fits in court every day. It's an out-of-court statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Here's an approach to hearsay. This is the approach that I like to use. It's really a shorthand way of analyzing hearsay, because in a courtroom we don't have the luxury to indulge in a thorough analysis like appellate lawyers do when they get the transcript after the case is over. We have to make quick split-second decisions, and so it's very important to kind of run through some steps in your mind, and that'll help you to recognize whether there is inadmissible hearsay that's being testified to, so that you can jump up and make the objection. And by the way, if you're ever in doubt, always make the objection. Always make the objection, because that's the way you preserve it. And even if you don't have a general idea of what the rule of hearsay is, or what the rule of evidence that's being violated is, if your gut tells you that something isn't right, stand up, make the objection, and even if you stumble with your words and you can't find the grounds, just get it out there, preserve the issue. I can't tell you how important that is. The appellate attorneys will be eternally grateful, because only when you object will you preserve the issue for appeal. Analyze the out-of-court statement. Determine first if there is even a statement, and then isolate it. All right, start with the basics. Step 2, determine who the declarant is. What that simply means is who made the statement. Is it the person in court testifying? Is it a party, or is it some other witness? You need to identify who the declarant is. Step 3, determine the purpose that the evidence is being offered for. And here's just the quick checklist. Is it being offered substantively for its truth, or merely to impeach and attack the credibility? These are basically the two possible purposes. Once you identify whether it's being introduced substantively for its truth or merely to impeach, then a lot is revealed. If it's being offered for its truth, you know it's hearsay. How do we know that? Well, the last part of the hearsay rule tells us that it's an out-of-court statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. That's why it's so important to determine if it's being offered for its truth, because then, and only then, do we know that we are in the world of hearsay. And by the way, then and only then do we proceed to the fourth step. Don't randomly or haphazardly apply the hearsay exceptions until you first decided that the evidence is being offered for its truth. If the evidence being offered is not being offered for its truth, then it's non-hearsay. And that brings up a whole nother discussion. Step 4, if it's being offered for its truth, apply the hearsay exceptions if possible.